Good morning, everyone. Okay, so let's begin our session one for the Environmental Law Teachers Online Training Program today. This training program is developed by the Legal Education Board in partnership with the Asian Development Bank, or ADB, and International Union for Conservation of Nature, IUCN, Academy of Environmental Law, and the UN Environmental Program. I am Attorney Maria Romina Bigumal, Program Coordinator of the Legal Education Board, and I will be your host today. The topic for today's session is State of Environmental Law in the Philippines, its evolution, challenges, prospects, and opportunities. Before we get started, I'd like to go over our house rules. Okay, please let us know if we could record this session today. We will only start recording if all parties consent to the recording. Mute your microphone while waiting for others to join and when not speaking during the session. You may also use the chat box option if you have any questions or comments. You can click the reaction option to interact with our speakers and guests. Lastly, kindly turn off your video camera after the picture was taken to lessen the amount of bandwidth for everyone in the meeting. We would also like to remind everyone that the links to the registration form as well as the evaluation form will be sent in the chat box. Kindly check your chat box and fill out the registration form to confirm your attendance. The evaluation form will also be sent to your email after today's session, and you may fill it out as part of your attendance. We remind everyone that the issuance of a training certificate requires your attendance to at least 9 of the 12 sessions. For today's session, we will also be having our breakout room session. For the breakout room session's instruction, enter the room where you are assigned by clicking the Join at the breakout room function and select your assigned room. The breakout room function is located at the right portion of your screen next to participant and chat functions. For your room assignment, please refer to the list of breakout room groups we sent to you earlier in the notice reminder last Monday. We will also be sending the list in the chat box, and you may also refer to it before the session begins. Before you enter the breakout room, kindly wait for other participants to join. As soon as the group is complete, you may now select a reporter and a note taker who will present the summary of issues discussed by the group. A report template will also be provided to everyone in the chat box. Please check your chat box for the link. The selected reporter and note taker shall also use the template to record the discussion of the group. This template will be sent to an email address which will also be sent in the chat box. The purpose of the breakout room is to encourage an interactive and substantive discussion between the participants on the issues they encountered within their respective locality as part of our topic sessions today. At the end of the 30-minute period, the small breakout room will automatically close. The host will monitor the time and will give a reminder 10 minutes before the breakout room closes. After the small breakout room, participants will then converge in the main room where the moderator will assist us as we share your group's discussion. We invite everyone to answer a short poll, which we will be flashing in the screen as part of our survey for the topics in our breakout room session. Kindly click the poll function located next to the participant and chat box function on your screen.
Hi, Mary. Can I also just say to all our participants, yes, so this is part of the idea of how we teach and options for teaching. And so the breakout rooms is one option to promote student engagement. And so that breakout room function is a function button that will be enabled after the presentation that's going to come from our guest lecturer, and then you'll be able to be assigned to those rooms or join the breakout room. So it won't be enabled yet. It'll be enabled in about 30 to 40 minutes when we're about to move into the breakout room sessions. So what I'm asking you at the moment, in terms of if you could just click on the poll to show or to indicate what you think are the top 3 environmental issues in the Philippines, and it could be in your particular area or the whole of the Philippines. You can just answer the top 3. So you've got a multiple choice, and so just pick the top 3 questions that you think are the most important for you in the Philippines. Thank you very much.
Thank you, Matthew. All right, we will just wait for another minute before we end the poll.
Thanks, Mary.
Okay, so I guess everyone has answered the poll survey. Is that correct, Angelo?
Yes, 70 of 70. We can close it now.
Okay, thank you so much, Matthew and Angelo. Now, for the documentation purposes of this training session, we would like to request everyone to turn on their video camera for a quick picture. Okay, we encourage everyone to put up a smile to welcome this morning's training program. Okay, for our ADB colleagues will be taking the picture. Angelo?
Hold on. All right, on 3. 1, 2, and 3. Hold on, please. Let me just check quickly. All right, one more. The next slide. All right, 1, 2, and 3. All right, that's everybody. Thank you. Mary, we're done.
Thank you, everyone. Okay, I'm having technical difficulties. Kindly wait for a few seconds. Okay, to formally start the program, I would like to introduce to you our resource speaker for today. We have with us Attorney Griselda Mayo Anda. Attorney Mayo Anda is an environmental attorney with over 30 years of field-based practice in environmental advocacy and community-based resource management work in the Philippines. She established the Environmental Legal Assistance Centers, or ELAC, in 1990, and now one of the Philippines' most active NGOs working to empower communities and local stakeholders to protect their natural resources. She is currently its executive director. Known as Jerty to family, colleagues, and friends, Attorney Mayo Anda has more than 2 decades of programmatic and managerial experience in various areas of nonprofit work, including policy development and advocacy for conservation and natural resources management. She also has experience for community development and human rights, fundraising for nonprofit environmental work, project cycle management, monitoring, and evaluation. She also actively participates in partnership building with local governments and private sectors on concerns such as climate change, coastal resource management, clean air management and legislation, protected area establishment and management, and community organizing work for natural resources management. She has received several awards and commendations for her environmental work, including one of the Condé Nast Travelers magazine in July 2000, which selected her from a list of global candidates in recognition of her work with the Palawan indigenous communities and the establishment of ELAC. The Puerto Princesa City Mayor's Award for valuable contribution to sustainable development and environmental protection was also awarded to her on 1998, and Grant Fellowship awardee, United States Asia Development Fellowship USEP program in 1994. She also received the Western Command 2004 Bayanihan Award for engagement with government and communities on environmental education. And on February 2018, she also was commended the Istorya ng Pag-asa of Vice President Yunor Robredo. She is a lecturer, a resource person on of seminars and trainings organized by the Philippine Judicial Academy or PhilJA. She is also a resource speaker for alternative law groups or ALG and government agencies such as DNR, DA, BIFAR, and local government units on environmental laws, new rules on prosecution of environmental cases, coastal law enforcement, climate change, and environmental governance. He is an author and co-author of various articles and publications on environmental policy, environmental governance, mining, REDD+, and corruption risk. She is a professor of natural resources and environmental law since the year 1996 and legal ethics from 1995 to 2020, and land titles in the Palawan State University College of Law. She finished her law degree cum laude in 1985 at the San Jose de Recoletos, Cebu City, and an undergraduate degree in accounting cum laude from the St. Therese College, Cebu. Ladies and gentlemen, please welcome Attorney Griselda Mayo Anda.
Good morning, everyone. Mabuhay from Palawan. Thank you, Romina, for such kind introduction. It's great to see a lot of practitioners here, professors, and also judges. I've seen judges. So just allow me to... Okay. I hope we can see the screen now. Can you see it, Romina? Okay. So I'll put it in, yes, there.
Yes, that's it. We can see it
so,
directly.
Thank you. So it's a privilege and an honor to be with you today, even for 30 minutes. So just quickly, my task is actually to share with you the evolution of the environmental law. It's an interesting journey, the challenges, the prospects, and the opportunities. And then quickly, if you look at environmental lawing in the Philippines, you cannot help but look at legislation. So quickly, it's good to review what has happened, and I categorized it to several years. Now, first is prior to 1970s because we do not have much time. Okay, and then the 80s, the 90s, and until now. So prior to the 1970s, we know that the colonially inspired Regalian doctrine, which is state ownership of natural resources, was a convenient mechanism to actually colonize, okay, and utilize our natural resources. That was actually, until now, the indigenous peoples still grapple with that, although we have the Indigenous Peoples' Rights Act. And the focus then was basically resource use and exploitation. So the approach was centralized and regulatory, particularly for forestry and fisheries management. We did have actually old laws then, no? Like we have the Kaingin Law of 1901, which many people now look at it as environmentally regressive. And then we have a Forestry Act, a Forest Act of 1907, and also a Fisheries Act of 1932. Plus, we did have a 1916 protection law on game and fish. And that was also amended by RA 3915. And this you can all read. I included references at the end of my talk. So it was not strictly environmental law in the sense that you take a look hardly on science, the impact on the people, issues of pollution, issues of climate were not there. So the environmental perspective was not written in these laws. But we were influenced, fortunately, in the 1960s with environmental rights advocates because of Rachel Carson's Silent Spring book. So it's a good book that talked about the impact of pesticides. In the 1970s, we were fortunate to have the Stockholm Declaration of 1972. I'm stressing this because it was an international document which recognized the right to a healthy environment. And right now, when we talk about environmental law, this has to be inextricably linked to human rights. We did have non-binding international sources, and we are signatories to the UN conventions. And these are important because they provide strong foundation for the Philippines to include environmental rights within human rights protection. In the 70s, that was a martial law era, but we know that we had, besides PD 705, the revised forestry code, we also had the Philippine environmental policy, which is the PD 1151, and also the Philippine environmental code. It was an attempt to actually integrate all aspects of the environment. And there were administering authorities which were included in these laws. And then 2 decades of martial law. Those were very challenging years. The decision-making was generally top-down. It was basically a regulatory approach as well in many laws. But it was good to see that by that time, there were already civil society formations like Haribon, although they were focusing more on animals at the time. Okay. And then in the late 80s, it's good to highlight critical policy and civil society developments in environmental governance, because you cannot actually set this aside when we recall the efforts towards achieving democratization. And it's good to highlight here, actually in the late 70s up to the 80s, the institutionalization of community-based natural resource management policies in the forest and fishery sectors. So government slowly recognized the importance of people participating in protection and also enforcement. So there were already participatory environmental protection policies and sustainable resource management technologies. And why are these important? Because we know that environmental law cannot swim alone as a regulatory framework. You really need people to understand and participate in protecting our environment. We participated as well in the World Environment Movement. There are many of these. And we started to also, well, not started, but we continued the engagement in developing policy. And there are lawyers here who participated in that process. Okay. In the late 80s, we know, following the People's Power Revolution in 1986, that resulted eventually in the crafting of a new constitution, a very progressive constitution, where environmental rights were shaped as state policies. While they do not form part of the Bill of Rights, I think in jurisprudence, that has been highlighted, that the Article 2, Section 16 is construed as the mother of all rights, is the flagship provision for environmental rights, and that is complemented by the right to health. So in the right to life, under Article 3, it's not just simply the right to live, but the right to a good life. And what is a good life? You know, health, not only mental well-being, but also being able to work, to study, to build a family, and many others. From the 1990s, okay, to the present, we are fortunate that we slowly shaped the institutional framework for environmental governance, democratization, and devolution. And we can see that in the major pieces of legislation, like the Local Government Code, the Fisheries Code, the National Integrated Protected Area System, the Indigenous Peoples' Rights Act. And it was also during this period that we had the Rio Declaration of 1992 with 27 principles, which included the precautionary principle and the Philippine Agenda 21. So we were actually one of the first few countries to develop a local agenda. And we had a social reform agenda, which was pushed by the Ramos administration. Now, it's also important to highlight from the 1990s to the present that we had already a lot of groups being formed, whether it was for community-based resource management, for building forest wardens, starting to organize women, being involved in fisheries, indigenous peoples, and many others. It's important to highlight the Oposa case in 1993 because here it recognized in domestic law the rights of future generations. Intergenerational equity, my friends, is a concept embodied in Principle 3 of the 1992 Rio Declaration. So the Oposa case as well declared that it is a duty by every individual to protect the environment. In 1994, there was also a case of the Laguna Lake Development Authority where the right to health was also recognized as a fundamental right. Okay, still to continue, there were so many laws passed from 1990s and up to the millennium. And there are many of them which you already are familiar with. The challenge is really giving life to these laws, implementing these laws. So you can see that in the screen. I'd like to also highlight some cases. Example, the Henares case, while it was not a positive decision, basically, on the LTFRB's duty, but the High Court recognized the right to breathe clean air. And you're also familiar of the social justice case where an ordinance was compelled to be enforced because it was an ordinance to reclassify portions of Pandacan and Santa Ana land from industrial to commercial use, which would eventually lead to the removal of Shell and all these fossil fuel companies, their offices there, okay, their plants. So it's important to highlight that eventually the Supreme Court, when these cases were filed, were also responding to the call of the era. Now, enforcement of environmental rights, as you know, right now, consists of various institutions. Example, in Palawan, we have the Strategic Environmental Plan for Palawan. So we do have a Palawan Council for Sustainable Development. But the superpower agency under EO 192, as you know, and also the administrative code is the Department of Environment and Natural Resources. The LLDA has a special mandate. And when we talk about actually, this is the PAB in the DNR, quasi-judicial body to hear pollution cases, plus the Protected Area Management Boards and the LTFRB. They do have special mandates, but they all contribute to addressing problems in the environment. Now, the PAMB has also a limit because they only deal with problems within the protected area, whether it's Mount Kitanglad or the Tubataha Reefs or the Sierra Madre, etc. It's also important to stress that in the law, in our laws, the state has the power to grant licenses consistent with the Regalian Doctrine. And this has been emphasized in the case of Ismael versus Deputy Executive Secretary. And therefore, even corporations who violate these laws are supposed to be accountable. And the state can also issue restraining orders and injunctions, but we know the limits and the powers of the High Court here. It's also important to stress that under our laws, corporations can be held liable. I mean, the heads or officers of corporations can be criminally liable for negligence in their operation. So there are many other cases on that. It's also important to stress on local government units. The case of actually the province of Rizal, when we talk about the sanitary landfill there, the case that the court recognized the local government unit's power to protect the environment. And so in the case of Tano in Palawan, with the passage of the live fish ban ordinance, in a sense, besides the DNR, you have the local government units playing a critical role in shaping environmental governance and environmental enforcement. Now, this case I'd like to share. There are many other cases because here there is an attempt, okay, by fishers and two lawyers who were stewards of the marine mammals to protect the Tanyan Strait or for and on behalf of the resident marine mammals. So this was a special civil action. The rules of procedure did not exist then, but they were concerned about a service contract to explore, develop, and exploit petroleum resources in and around the Tanyan Strait. So there was seismic survey and oil drilling. Now, the service contract was an issue, but the question was, do marine mammals have standing to sue? Okay, but then the court said that need not be squarely answered, okay, because the lawyers here and the fishers were stewards of these marine mammals. And the High Court was very legal here because they said that the service contract failed to comply with the safeguards in Article 12 of the 1987 Constitution. So it was not signed by the President, it was not authorized by general law, and not reported to Congress. And the court also underscored the violation of the EIA system because there was no ECC and the NIPAS law was violated, okay? Because Tanyan Strait was a protected area. I'd like to highlight good practices, and lawyers here have been part of this. Many of our environmental lawyers contribute to localized efforts towards multi-sectoral enforcement efforts, and environmental law is significant there. We have also contributed to crafting local legislation to establish watersheds and even protected areas. Research is an integral part of environmental law because jurisprudence is evolving, and then monitoring because we have to also determine whether our laws are really being implemented well. There's a combination of strategies like public interest environmental litigation when you sue DOE and DNR on why coal plants are still being allowed in this country, or why fishery regulations are not being implemented, or why mining is being given a lot of incentives. But litigation cannot swim alone. You have to complement that with advocacy and awareness raising strategies. And that's being done in this country. We're also fortunate to have seen community actions in the Kaliwa Dam project that's seen Baguio. The lawyers from Baguio can tell stories, the use of social media, and of course, incentives, resource-based community livelihood. And I've seen this everywhere in the country where environmental lawyers working with civil society groups, enterprise development groups have pushed for community livelihoods. Okay, the challenges, I do not have much time. Institutional issues and concerns. This is really very apparent. On forestry, it used to be one forester protecting 10,000 hectares. Right now, it's 4,000. But we have seen foresters here everywhere in the country. In Palawan, 4 para-enforcers have died, have been killed. It's not easy to manage even 1 hectare or 10 hectares of forest. So the government has tried to complement that with community-based forest management agreement schemes. Limited budget. Enforcement is a cost center, and so is research and monitoring. But you do not see that being debated upon in Congress. Now, legal instruments have also been used for illegal activities. And of course, the ugly head of corruption. So PD 705 is among the most antiquated laws. We have the National Land Use Management Law and the Sustainable Forest Management Bill pending in Congress for more than 10 years now. It's time to actually amend these laws. Okay, other on the enforcement side, for those who litigate, like I've seen this, modesty aside, in the criminal cases. So if the enforcers are not familiar with the provisions of the law, then they do errors, no, in the complaints, in the affidavits. And then we've also seen the rules on arrest not being complied with. So we have seen enforcers being sued. Okay, this you already know. And with evidence, very, very important. In the past, when cases they actually take 10 years. I had a case of 10 years and witnesses dying. So then eventually it's archived. So this is really sad. And therefore the violator continues to commit the crime. Now, issue on jurisdiction. I think that has been settled by the rules of procedure, but there are administrative remedies also with judicial remedies. So for a while, the DNR was actually asking on whether they can continue with the administrative adjudication case on forestry before a criminal case is filed. But those cases actually can proceed together. Harassment suits are also aplenty. And I'm glad to tell you, modesty aside, that our batting average on SLAP is 100%. Like example, a barangay captain was sued 6 cases by a mining company. We all got that dismissed, including farmers who have been sued with libel. Okay, but we have a challenge now. A mayor has been harassed and suspended because of a complaint of a mining company here in Palawan. And for media people, lawyers, okay, libel is there. Plus, of course, the killings of lawyers, which in the Global Witness Report, the Philippines is a dangerous area for environmental defenders and human rights defenders. So we go to safety and integrity, which is also a challenge. So of course, we know, I've also suffered from red tagging and also other environmental laws, but we've dialogued with the military there. So this is an important challenge. Okay, I have not much time. The delays, I've said that already. And then the witnesses. I'd like to highlight here expert witnesses because not all scientists are willing to testify. While we recruit interns to become environmental lawyers, witnesses are also difficult to encourage to become witnesses. So it's worrisome if you have the same witness and he is harassed, or she or he is harassed. So that is an important area of work. Okay, chain of custody, we've had cases dismissed because the enforcers were not able to ensure the chain of custody and documentation and authentication as well. Okay, lack of lawyers is a continuing problem now. When you go to the farthest area of Sierra Madre or Mindanao, they even call us to say that they need lawyers there. Now, prospects. I am sharing these concepts because I've seen this in 30 years of work, that there's a debate whether you have to be anthropocentric, which is human-centered, and which unfortunately has been the ethic of utilitarian tradition. So we have destroyed resources because of that. Or biocentric, you're nature-centered, you don't want human beings to destroy the environment. But sustainability is an important concept. So how do you strike the balance? And I've seen through the years that we've pushed for good environmental governance, where environmental law is very significant. And then you've seen as well, and the Supreme Court is pushing for this under the rules of procedure for environmental cases with the concept of environmental justice, where Justice Puno and Justice Corona was saying, it's a combination of social justice and environmental protection. And then climate justice, with the cases now exacting accountability from corporations who are main contributors of greenhouse gases in the world, and the rights of nature. Okay, that is also, I think Ecuador led that, and there are advocates pushing for that now. So the prospects, public interest litigation, we still need to build on that. We need to have more cases that would build on jurisprudence, on environmental liability, and also giving life and value to the rules of procedure for environmental cases. Corporate climate human rights litigation actions can be considered. you can take a look into fossil fuel projects just around where I work in Palawan. There's so many service contracts there. One service contract is just adjacent to the Bataha Reefs Natural Park. Is that possible? Is it possible to uncover the historical responsibility of fossil fuel corporations for human rights violations? So these are some of the questions. Second, we need to strengthen enforcement. And to do that, environmental lawyers like us should participate in capacity building, national and local. And then we have to use science, total economic valuation, training, of course, that's there, and then monitoring, because they need scientific and economic and technical support there. Okay, research and monitoring of cases should continue, but in the local level, there are many of us trying to do our small share in crafting environmental codes, in formulating a sustainable development agenda, in localizing sustainable development goals. So there are many opportunities. Another area is environmental law clinics. Sorry for the typo error. And internships. So many of us are doing that, establishing clinics in law schools. And hopefully we can have the second, third, or fourth generation of environmental lawyers someday. We also need to promote research and learning in the field of environmental law in our schools and in our communities. How do we make sure that our governance systems respond to the needs of our ecosystems? Why do we push for build in areas which are rich in biodiversity, like Dumaguete reclamation? Okay, how do we respond to the dolomite, okay, issue in Manila Bay? So there are many questions as we proceed. Now, advocacy. 50% of my time is also in this area of work, and I have seen that we can push for policy reform, but we can also compel government agencies to do their work, to do their job, not only through litigation, but also to advocacy work. Whether you want to alter power relations in the community, indigenous peoples versus corporate plantations or mining companies, or changing attitudes. It's very difficult because just giving broader impact to a policy and program may take ages, but it can be done, and it has been done. So opportunities, there's the Sustainable Development Goals by the United Nations, but on the local level, I'd like to highlight the rules of procedure before I end. So you know that this is a perspective of the Supreme Court, and the objective is not just to advance our constitutional right to a balanced and healthful ecology, but to address issues on cost, speed, okay, and simplicity. And it attempted to be innovative and to promote best practices, plus enabling court to monitor this. So these are the highlights of the rules, okay? I know that you have read this and are familiar with this. So I'd like to highlight, there are many slides. From experience, the EPO on the local level can actually bear fruit. You know, when you push, for example, protecting a mangrove area or protecting farmlands or your forest against mining. Okay, so the EPO is both prohibitive and mandatory, and that's good. And you can use that for the writ of Kalikasan. The TEPO is challenging because it's only 72 hours. There are courts who would say that it could no longer be extended even if there was no hearing within 72 hours. But there are also courts who have extended it for a year. So we know, to me, it's a conundrum. There's a gap there, and we need to have cases to somehow either improve jurisprudence or amend the rules. The writ of Kalikasan, the challenge there is 2 cities or 2 provinces, and you have to establish magnitude. So there have been cases which have been dismissed, no? Because the magnitude has not been established. Mandamus, okay, the writ of Kalikasan and writ of Konting Mandamus, I have seen that the privilege of the writ was, the only privilege of the writ was awarded in the Greenpeace case, okay, on the BT Talong. But it was also reversed completely because the case has been moot and academic. So Mandamus, this is interesting because we need, you need to be directly aggrieved here, and it's directly, it's directed towards an agency of government. Citizen suit, the court has liberalized standing, so that gives you the opportunity there. How do you make sure that the OPOSA case is pushed further? You know, you take an extra mile so that ordinary citizens can assert their rights. It's speedy. There is a consent decree there. Okay, this needs to be developed. I haven't seen this yet in practice. Okay, even the speed. The earliest I've seen in my work is 2 years. It's not 1 year. 10 months is even short. Okay, and then the precautionary principle. This is something that we need to still build on. It's just the Greenpeace case because the Mosqueda case on the ban on the aerial spray was not favorably acted upon by the High Court, because absolute certainty also requires that there was science, no? There was scientific research. So that's the difference between those cases. SLAP is very favorable for us because we will all be sued. Libel is a very common SLAP suit to lawyers, media, advocates. And then I'd like to share before I end, no? Because it's almost, I think, 30 minutes, that when we reviewed about 12 cases before the RPEC and after, we are good to note that the standing to sue is still liberalized. So the court has continued to recognize that even if there have been attempts by the respondents in these cases to dismiss it because of standing to sue. So citizens as stewards. And then the constitutional provisions on Article 2, Section 16, no exploitation protected areas, okay, approval of service contracts, and then upholding the provisions of the local government code on prior consultations. The Boracay Foundation case is important to highlight. And then the application of precautionary principle, okay, in the Greenpeace case, but I would say because it was dismissed, while the precautionary principle is still there, we need to, you know, file new cases to make sure that the principle is still upheld, okay? And we need to expand it. And then converting the EPO into a writ of continuing mandamus that we've seen in the cases that we've reviewed, plus sustaining the mandates of government agencies. So example, in the case involving the road sharing, okay, and against the Climate Change Commission, the court was saying that the DNR was doing its role. Even in the case that we filed, which is still pending in the Supreme Court on coal, we won against the Department of Energy, but the DNR's mandate was still upheld, okay, that they were still implementing their work. So the challenges, I think, because environmental law is more than 90% science, we need to work with scientists and we need to make sure that evidence is there, okay? And then we need to enlighten the courts, we need to enlighten ourselves about the scientific aspects. Example, when you want to establish that natural forest, which is about to be mined, is rich in biodiversity, it's not just simply indigenous people saying that. You need research. So we got a scientist to do a high conservation value assessment plus a total economic valuation to make sure that we can show that the value of the forest and environmental goods and services far outweigh the value of the minerals. Now, exhaustion of administrative remedies, you know, the hierarchy of laws, these are things that the Solicitor General and other respondent agencies always highlight. So that's a challenge. So far, we haven't been dismissed yet, no, on that ground. And then the requisites, because in the case of the energy case, the coal case of Agham in Subic Bay, the court was saying that you have to make sure that the requisites are in place. And then FPIC, because in that same case, the free and prior informed consent need not be in place yet when you push for EIA. So to me, that's a challenge because you need to assert the Indigenous Peoples' Rights Act. So some insights, I think, in closing. I would want to encourage environmental lawyers, professors to contribute to monitoring these cases so that we can see if the jurisprudence is there. We need to give life to the rules of procedure for environmental cases. and also do our work, educative work. That's why the cases are not that many. Many affected communities are still not able to avail of these remedies. They do not know what rules of procedure for environmental cases are all about. So access to justice is a real issue. So in closing, my friends, thank you for listening. I encourage that we continue to teach, we continue to inspire students, we continue to participate in advocacy work, in public interest litigation, in crafting local policies, because that is part of efforts in giving life to the law. After all, it's practice or experience which strengthens environmental law. Thank you very much. Mabuhay.
Thank you so much for that very substantive discussion, Attorney Griselda Mayo Anda. All right, so now for the question and answer to our participants. If you have any questions, you may click with the raise hand button in the reaction function located in the right side of your screen. You may also send your questions in the chat box and we will just read it for you. So anyone would like to ask or clarify any part of the discussion of Attorney Anda's lecture? Okay, so I found this one comment from Attorney Maria Concepcion Hernandez Veloso. She commented that we don't have SC cases sample or jurisprudence for SLAP cases, and she hoped that we can gain access to lower level court decisions, house them in a database for academic use.
Yes, that's an excellent observation, and that's correct. Many of the SLAP cases have been dismissed, Attorney Veloso, in the level of the prosecutor, okay, in the court. And I think that's a good project. We take a look how the courts decided on it. One case, we've submitted position papers, okay, in 6 cases. But there's one case now involving Mayor Jean Feliciano, who was sued by Ipila Nico, and she was suspended for a year. So that is still ongoing. There's a motion for reconsideration, and we will see how it goes. So it's still in the ombudsman, but we're noting that now. Thank you, Maria Concepcion.
Okay, we have another question here, Attorney, from Attorney Tin Hitai. What's your suggestion for legislation to get effective remedies?
Okay, it's not just simply legislation. But for legislation, I think it should include budgets. You know, if it's a local ordinance, there must be a budget for enforcement, because that you do not see. Because enforcement is a cost center, and if, let's say, you pass an environmental code or an amended fisheries code in the local level or a protected area, okay? But if that ordinance just provide for fines and penalties, but there's no regular allocation for a budget, I think how can laws are only as good as their implementation. So you have to make sure that there are funds to implement it. So therefore, you need warm bodies there. Of course, while I say that, there are pending bills in Congress now to amend the Forestry Code, the Public Land Act, which is 1936, and also the mining law. But it's taking ages to do that. So to me, a faster route would be local legislation. Example, if you have an environmental code like in South Cotabato, where up to now, they have, the ordinance provides for banning open pit mining. So of course, there's an attempt to change that now, but that provision is still there. And that's why they're able to protect their forests, their ancestral domains, their key biodiversity areas because of that provision. So that, to me, in conclusion, you have to complement legislation with, to me, hard enforcement, a budget for that. With the Mandanas ruling, I think there will be more funds now for local government units. So hopefully we can get involved in shaping environmental governance. Yes. Okay. The Climate Change Commission, can I respond to that?
Yes.
With all due respect, to the CCC. The law was amended by the People's Survival Fund, but there's a strategy and a plan, but I do not see funding to implement it up to the level of the local government unit. So the projects are there for education, but again, with all due respect, it's so limited. It's so limited. They could not respond, example, how do they contribute to the energy plan, the Philippine energy plan? Is it consistent with our nationally determined contributions? Because we are signatory to the Paris Agreement. Okay, so perhaps that can be a subject of climate litigation. And then I'd like to respond to Warren Concepcion, Romina, if I may. That's
Oh,
an excellent, it's an excellent question about election time. Yesterday, we had a long meeting because we wanted environmental lawyers to participate now. What's the sustainable development agenda? What's the environmental agenda? So perhaps, or climate justice agenda. I think we can contribute there. What are things we can recommend, okay, to them? But doing that means knowing or having a good sense of the problems on the ground. Because we can only recommend, right? If we know what's happening in your area. So we should participate. And then the rights of nature, yes. Can forests actually sue? Can forests speak for themselves? Can a pangolin, whose habitat is being converted to corporate plantations, or fish, which is a fishery area which is being overfished, can they actually have standing to sue? So at the moment, in the marine mammals case, which is the closest, the court said that the petitioners were stewards and they represented the marine mammals as stewards. So that's the closest. I think we need to develop that area based on our experience. Attorney Maki is here, no? He's part of that group. And there's a pending bill, I know, in Congress, supported as well by the Miserior group. Okay, about the trend of kalikasan, thank you. It's not, again, with all due respect to the High Court, the writs of kalikasan, many have been dismissed. In the case example of Arigo in Palawan, no? Against the USS Guardian, that was dismissed, as well as in the case of the Subic Bay coal plant. The requisites are not there. That's what the High Court said. And the cases are still pending. But I think it's cause for concern why these are not positively acted upon. The only privileges I've seen was the Greenpeace case. No? There's also an Agham case actually on mining with writ of kalikasan. Only those two cases. But we know that the merits, okay, of these cases need to really be ironed out on the local level. So thank you, Lisa, for that. It's not a good trend. So therefore, there's a lot of work to do from our end. Thank you.
So we also have another question here, Attorney Griselda or Attorney Gertie. From Attorney Aris Matibag, should we push for codification of environmental laws and repeal those outdated laws such as Envi Code? Thank you.
Yes. Yeah. Thank you, Aris, Attorney Aris Matibag. I believe so. If we can already, well, the National Land Use Management Act is an attempt, no? But our environmental code, PD 1152, is also antiquated. Okay? So you need to craft a new one. But because the local government code also gives a lot of mandates and powers to the LGUs, perhaps you can craft local environmental codes like what we did in Puerto Princesa. Okay? In many areas like Misamis, South Cotabato. So it can be done. Localizing it, because local government units can shape their own destiny, no? Their own fate, just like banning mining in their area. So to me, that can be relatively manageable because we're there, we're teaching in those schools, and we can work with advocates in the local level. Of course, the congressional area of work is still important, but it takes time. It takes time.
Okay. So we have also Matthew who's been raising his hand. Matthew, would you like to ask Attorney Gertie some questions?
Thank you. I know I'm an organizer, but I'm always excited about Philippine environmental law. And there are some really interesting questions. So I wanted just to ask you, you mentioned in terms of local government officials and you know, this mayors and others of barangays who have been targeted by slap suits or cases. This is something that I think is quite sort of shocking from an idea that state officials or officials seeking to enforce laws would be legally attacked by you know, anyone. Is there a way that these officials can be protected? You know, certainly, you know, defendants and respondents have the right to be heard in court, but this seems to be going beyond exercising those rights and being very aggressive. You know, it's something I think that is happening more and more, but certainly in the case of officials in barangays, those who are mandated to actually comply the law being targeted because they're taking action in accordance with their mandates. I'm just curious if there's a legal provision, or is it something that requires legislative amendment? Thank you.
Well, actually, the presumption of regularity is a doctrine which has also been invoked by officials being sued for failure to implement laws. I've seen that also in our mining cases. But for officials who implement and enforce the law, Matthew, first, thank you for that question. They invoke the SLAP. And that's why I said in the barangay captain who was sued with 6 cases, modesty aside, we had those cases dismissed. But in the case of the mayor now, it's an ombudsman case. She invoked the SLAP, but that was not considered. So there's a motion for reconsideration now, and understand that will really end up going to the High Court. So I think my own sense there is we may need to do more research, okay, to me, and look at the experience and see how we can help our champions. Because you do not see many champions on the local level, no? You know, we see a lot of problems. So how do we, beyond SLAP, how can we make sure that they will not be subjected to such harassment for a long time? So that's a wonderful question, and to me, it's an area of work that we need to do, you know, for local government units, because you do have Section 16 you can invoke, okay, and other provisions of the local government code. But if they say that you abuse your authority, because that was the case, you abuse your authority, and they had evidence, etc., and then you invoke SLAP. At the end of the day, it's really the evidence and the way the ombudsman or the court will appreciate it, Matthew. So that's the challenge. Thank you. I'd like to respond to Judge Nono. Good morning, Judge. He was asking about administration. To me po, it was between Ramos and also Aquino, where I've seen a lot of efforts on enforcement, particularly between 2010, okay, to 2016. Because it was during that period of 2010 to 2016, Judge, that we had the rules of procedure. And we had a lot of dialogues, you know. We also attempted to monitor many cases, although monitoring was before that, but we did do our share of monitoring fishery cases where the batting average in terms of conviction was only 20%. So that is my answer. I mean, based on experience. And then environmental damages, Kenneth, no, Fabula, that's a good question, because that is where you need science. That's where you need experts. Example, the court will want to know, okay, what really was the extent of the damage to farms. And to be able to do that, we will have to show the quantification of an agricultural officer. And it's good that the Mao spoke. He was a witness, and he identified the hundreds of hectares that were ravaged and destroyed. So that was considered by the court. That to me is a work also on our part, no? Unless there can be legislation to actually have a criteria for establishing that. Otherwise, it's work from our side, no? Valuation, and then, but we know that there are actually rules on like quantifying forestry. The DNR has that. Okay. And then harmonizing customary laws. Fantastic, because many courts do not still understand the concept of ancestral domains. And we have a pending case now, implementing the IPRA law because a corporate plantation encroached into the ancestral domain. And because it is still a certificate of ancestral domain title application, you have to show that there is indeed, it has been time immemorial. So we have to show evidence. Fortunately, the NCIP testified. So I think there's more work in that area, even for evidence. NCIP has had a lot of regulations, and I think the expanded NIPAS law recognizes IPRA. You have indigenous community, indigenous and local community conserved area. So that's already an attempt, Ophelia Pilar, to harmonize that. Okay. Now, the coal moratorium, oh my gosh, that's a very old law, and we do have the renewable energy law, okay, plus and other attendant laws. It's a challenge for really enforcement. That's why we are proceeding with public interest litigation. I have one cold case now on the local level, but we have a case pending now in the Supreme Court, still on the policy related to coal. Thank you for that. No.
Okay.
Thank you.
Okay. I guess that we have some few more questions here in the chat box, so we'll just entertain the last question. This is from attorney Errol Torres. So he asked, for us new in this field, how and where can we access model pleadings or legal forms filed by environmental lawyers or groups?
Okay. I think that is one work that we should do, because there are environmental lawyers here in this group, and we can take a look at the pleadings filed in the marine mammals case, Oposa case, in the Greenpeace case. We haven't compiled them yet. So that's also a project. Thank you for your wonderful questions and insights, because I think we have work to do, research, monitoring, compiling good pleadings. The trainings of the EDB are excellent, but we are building on these groundbreaking efforts to bring it forward. As I said, laws are only as good as the implementation. There are nuances, as you can see. How do you make sure that, interested young lawyers can know more besides trainings? And I think clinicking and mentoring sessions, roundtable discussions should continue, because we need young lawyers. People like me are getting old, so we need to inspire more lawyers. Yeah, conversion, Judge Nono, is also one of the pending cases now. So that talks about environmental governance and land use. Thank you.
Okay. To end the lecture, we would like to award this virtual plaque to our resource speaker for today. Also, the Legal Education Board presents this virtual plaque to Angelo. Can you play the video? All right. So, the Legal Education Board presents this plaque of appreciation to Attorney Griselda Mayo and the Executive Director of Environmental Legal Assistance Center, or ELAC, for sharing her time, knowledge, experience as resource speaker during the Environmental Law Teachers Online Training Program, first session, State of Environmental Law in the Philippines, its evolution, challenges, prospects, and opportunities. held via Zoom virtual conference and given this 29th day of September in the year of our Lord 2021 in Manila. On behalf of the Legal Education Board, signed by Chairperson Ana Marie Melanie B. Trinidad. Thank you, Attorney Gertie, for that wonderful discussion and very engaging discussion with our participants. So if any of you have more questions or some concerns, or would you want to talk more about the discussion of Attorney Gertie, you can just send your questions to me. We will also send my email in the chat box later during our breakout session, and you can send their questions to us and we will forward it to Attorney Gertie. So thank you very much.
Thank you for the excellent questions and insights. There's more work to do, but seeing all of you here inspires me that there's a future. Thank you.
Okay.
Thank you very much.
Thank you. So now we move to our breakout room session. So let me read again to you the breakout room instructions. So enter the room where you are assigned by clicking join at the breakout room function and select your assigned room. The breakout room function is located at the right portion of your screen next to participant and chat function. Can everyone see it? Okay, so you can see it by clicking the function more found at the very end of your right screen. So click more and then a pop-up message will show you the following options: record on this computer, record on the cloud, and breakout rooms. Kindly click the breakout rooms later. Okay, so we have some few concerns from our participants. It seems that they cannot see the breakout room functions.
It's there already. You can see it now. It's there.
Okay, so
my breakout room function already.
Okay, so can everyone now see the breakout room function? Okay, so once you enter the breakout room, kindly wait for other participants to join. As soon as you are complete, you may now select your reporter and a note taker who will present your discussions in the main room. For your room assignment, please refer to the list of breakout room groups in the chat box sent to you by one of our team members. A report template will also be provided for everyone in the chat box. So please check again your chat box for that link. It's entitled Session 1 Report Template. So the selected reporter and note taker shall use the template to record the discussion of the group. And the purpose of our breakout room is to encourage an interactive and substantive discussion between the participants on the issues they encountered within the respective locality. As a guide, you may answer the following questions. So as you fill up the report template. So first, what are the challenges you have encountered in the implementation of environmental law in your locality? The second one is, what are the prospects of environmental law you foresee in the next years? And the third is the identification of opportunities to improve environmental law in the Philippines. So at the end of the 30-minute period, the small breakout rooms will automatically close and the host will monitor the time and will give a reminder 10 minutes before the breakout room closes. After the small breakout rooms, participants will then converge into the main room where the moderator will now assist us in the sharing of your group's discussion. All right, so you can now click the breakout room function and select the room where you are assigned.
I think is everyone here now?
Yes, everybody's back, Matthew. Go ahead.
Yes, sir.
Thank you very much. So thank you, everyone. Both Mary and I were jumping around from breakout room to breakout room. And so we're going to have what we call, a report back session. But I'm going to choose just 3 groups to give them maybe 4 minutes to report back. But we wanted just to mention the reason or the issue about breakout rooms. So today, as part of the pedagogy of online learning. We've had the guest lecture with questions and answers. And so that, I think, Attorney Jyoti has identified a whole range of issues. And now with the breakout rooms, we've tried to get you as the students, as the student professors, to think about the environmental law issues and the environmental issues in a broad context. Now, as you know, when we went into the breakout room, we had 100 students, student professors, and then we divided them prior to in terms of groups, and you saw how that there was a time issue in terms of using the technology, and there's always going to be technological glitches. And so this is something that we as teachers need to be aware of, how to use the technology, but also of its limitations. And some of the rooms we had planned that each would be a similar size, but group one, I think you were one of the largest groups in terms of numbers, and others we had to close so that we would get large, 7 or 10 people in each breakout room. So the breakout room enables that student discussion, and the professors and lecturers can move between the breakout rooms, but it also does have limitations because you're not listening, or all the students aren't listening to each other. So now we're going to have a report back session, and we've often in conferences that we've all been to, you'll get each group will have its chance to report. Sometimes because of time pressures, we don't have that time. So therefore we single out either an issue that we want all the groups to just focus on, or as in this case, I'm going to pick 3 groups at random and ask those groups to have 5 minutes or 4 minutes, if you can, to report on the issues. In terms of the other groups, and in particular group 1, and I saw Attorney Galahad and Attorney Donna were there, we might also talk about you next week for a little bit. You can bring back on those issues. I would like to ask though, room 4, group 4, is there someone here who can report back? And it's group 4, group 6 and group 9. I'm going to ask a volunteer from each of those groups if they would be able to give a short discussion, and if they can show their screen, that's even better. So could the reporters back from those groups, can they raise their hand using the reaction button or unmute and let us know who they are? Okay. From Ascot, Rocky.
Hi, good
Professor
morning,
Rocky.
Matthew.
Thank you.
Good morning, classmates. Thank you to the LEB and the ADB and the organizers for this event, where we can share our views and learn from the experts. Good morning, everyone. I am Rocky Duhungko. I am a lawyer, and I am from the Aurora State College of Technology. So our group is made up of individuals with diverse practices. So we were able to share several points of view regarding environmental law. First and foremost, as an educational institution, here in Ascot, we specialize in forestry and environmental sciences. So as an institution, our perhaps problem area is that we have the science, we have the practice, we have the expertise, but we do not have the legal expertise yet. So under prospects and opportunities, actually our college right now has a pending application with the Legal Education Board for the establishment of a College of Law here. Another pending application that we currently have is the offering of our course on marine biology. So I guess for educational institutions as a whole, maybe schools and universities can look into offering courses and programs that are related to the environment. Because like in the Philippines, we know that there are only about 20 universities offering the forestry program as a course, and maybe less universities offering the marine biology program. So it would be good for everybody, because it's not just an environmental law perspective, but also from a scientific and practical application perspective as well. Second problem area that we identified from our group is that it seems that there are only a few lawyers who are engaged in the in the practice of environmental law itself, due to the not so lucrative nature of the practice. One of our members shared that one way to address this is actually to expand the practice by including, say, project development practices, so that like for example, our speaker earlier, she was able to establish an NGO, so that the practice will just not be limited to environmental law itself, because it is somewhat based on a voluntary and socio-economic sense of socio-economic responsibility. So maybe we can also expand the practice so that it will also be rewarding for the lawyers themselves. And then on the environmental issues themselves, of course, it was also mentioned by our speaker, and we can confirm it in practice that there is a limited human resources in the DNR in practice. And what we can do, and the illegal activities currently happening in the localities are mostly because of the lack of livelihood in the for the people who are involved in these activities. So maybe one way to address this is to offer or make them aware that there are alternative livelihood programs that they can enter, which are sustainable, or if they would remain in that industry, maybe they can be taught to engage in sustainable activities instead. So like in ASCOT, one of our programs is woodworking laboratories for upland farmers. Although it involves wood products, we teach them to use sustainable wood materials for their livelihood. So it would at least lessen the harm to the environment. On the violation side, and this is my last point, sorry Matthew if I'm extending a bit. On the violation side, one thing that we noted is that most violations, especially those that are happening on a grander scale, go unnoticed unless there is a report of the violation. And most of the violations in the local communities consist of petty violations, such as cutting of a tree or two between neighbors. So maybe the practice and the legal framework itself can focus on violations of a larger scale, where the limited resources of the government and the practitioners can be put on, rather than just the petty violations themselves. Thank you, Matthew, and thank you to the panel. I hope I did our group justice. Thank you to my group mates.
Salamat po, Attorney Rocky. Thank you very much. And so we'll hear from now Group 6. If we could have someone from Group 6. And I should just say, Attorney Rocky, when you mentioned marine biology, I'm always excited because my brother is a professor of coral reef ecology at James Cook University in Australia, which I've always thought was just an excuse for him to go scuba diving. He never denies it, but it also shows how, there's potential for international connections. So thank you very much. So Group 6, do we have a spokesperson from Group 6 please raise their hand or turn on their microphone, and Group 9? Is there someone here from Group 6? I think this was from Ateneo de Naga or West Visayas State University.
Hi, everyone.
Hello. Hi, thank you.
We volunteered Sir Marlon, but I think there he is. Sir Marlon, I see you smiling. So Sir Marlon would be the reporter for Group 6. There you
Thank
go.
you.
Okay, okay. I'll take the challenge and the opportunity. I just hope that everybody can hear me.
Yes.
Okay, yeah. Actually, I am from Masbate, and I am a public school teacher. And while preparing for my modules, I came across with this invitation from the Legal Education Board. And I said this could help the public school system in Masbate. Anyway, again, I also hope that I could do justice with my group mates, because most of the time during the discussion, I was cut off, my internet connection was cut off. But anyway, most of us are from Bicol region, and the Bicol region generally, when typhoon comes, so we are being battered over and over again by typhoons. So our main concern are the effects of the typhoon, these calamities. So the challenges is after the typhoon, there will be destructions, there will be loss of properties, there will be loss of, sometimes loss of life, very challenging. And again, loss of communications and power supply. So this is the current problem now in Masbate City. So maybe the prospect is how could we address these concerns in the near future, and more on environmental laws. How could, especially that there's a forthcoming election, so it is now high time for us to choose leaders, leaders who have the heart, leaders who have the experience, and leaders who have the courage to stand for what is true and what is right. And another thing that was observed, I shared probably on experience as a public school teacher. Most of the students, especially in the public school where I came from, so they do not, actually they do not know about the environmental law. So there is an absence of information, there's an absence of, maybe there's an absence of commitment because these kids do not know. And the basic question is, whenever I talk about environmental law in my class, the basic question is, sir, what does it have to do with me? Why should I be concerned? What benefit will I get from it? That's one question. The other question is, if I get involved, how do I get involved? Where do I go? To whom do I need to talk to? And as a student, I am a student grade 11, grade 12. What can I contribute to this movement? So these are some of the things that we notice. And in fairness to my group, if one of my group mates could also share, because during the discussion I was cut off. I don't want to focus only what I shared. I know that you can share much also. So maybe one of my group mates can add, because those are the things that I noticed. I was able to jot down some notes, but the other proceedings of the sharing, I was cut off. Maybe Ma'am Grace could also add to the group.
Thank you, Paul. I think Group 6 has already sent in a report, so we can share that also with the group as well. So,
okay,
thank you very much for that.
Okay.
I like the idea. What does it have to do with it? Very good question. So can I now ask Group 9? Because I also noticed we're getting to the end of our time, and your time is Group 9. Is there a spokesperson from Group 9 who can give a quick conclusion?
Yes. Hello, everyone. I think, Sir Kenneth, are you here? Kenneth? Lim? Can you please share very briefly our output in Group 9?
Okay. Sige, I'll take the challenge. Thank you, Attorney Zamora. So this is what we discussed in our group. As you can see in the screen, one of the challenges that we are facing is that how do we enforce these environmental cases? How can we run after these offenders? So what we decided is that I think we should train the prosecutors and environmental law enforcers on how to go about this, how to go about the prosecution of these offenses. And one of the opportunities that we have seen is that we have to offer MCLE subjects or courses for lawyers and prosecutors, and train the law enforcers on environmental enforcement. Okay, we can also have an agreement, a partnership between the DENR and IDP with regard to the implementation of this environmental law cases. No, I think when it comes to prosecution, one of the challenges is the gathering of evidence, and we need to have experts, no, with a scientific background. And one of our group mates shared that it's quite expensive. So that's one of the challenges that we see, no? And also we have to empower the LGUs and the government agencies on how to regulate and the enforcement of the environmental laws. And we also see that there is a conflicting jurisdiction, overlapping of claims and like permits, licenses, and yung mga claims ng mga indigenous people. Okay, so I think there should be a law, no, to delineate the jurisdiction of which agencies or which courts should handle these environmental cases. And one of the opportunities that we have seen now is that we can offer itong natural resources subjects in law schools, because currently I think there is a move to reduce the units, no, to 2 units. So we think it's better to retain the course as 3 units, so that we can learn more, so that the law students can learn more about this, the intricacies of the law. And also, I think there is a pending bill on National Land Use and Water Bill, and I think we can help in making sure that this bill would adequately address the current environmental concerns. No? And lastly, since, as we know, the election is forthcoming, we have to campaign and choose for leaders who have the heart for the environment, because at the end of the day, these are the people who will enforce, you know, our laws. Because we have the supporting role, but we need these people that who are really committed to defend and champion for our environment. So I think I have used up our time. So thank you very much especially to our group mates, because they have shared a lot of amazing insights. So I learned a lot from them. Thank you very much.
Thank you very much, Sir Kenneth. Thank you very much indeed for that rich sharing, and we will gather those reports. So please, whatever you have, if you can send to us. I mean, if this was the first or second session for an environmental law course, we've already got a rich number of topics for discussion and debate, or student projects that students can do. And so this is part of what we're trying to think, is how we can then excite students, and we're all students, in terms of that learning and how it goes on through the course of teaching over the semester. So I want to thank all of the groups for all your participation, and if people could share and send their reports, we can use this, and it also helps as a basis for considering what other steps are needed to ensure that the environmental and natural resources law curriculum development and training and teaching is very relevant to students. And I think one of the things we recognize is that students these days, they want to know how it relates to them, how it will benefit them. We know how important the environment is and how intimately it is important. But, you know, we also know that lawyers say, well, is this going to be in the bar exam? Is that what I have to study? And these are some of the other key issues in terms of promoting and developing environmental and natural resources law. And Ralph has also asked to remind everyone, if you could fill out the attendance sheet, and there's a short evaluation form. And again, constant evaluation is very important for us to be able to modify the course and ensure that we are meeting your needs as teachers, just as teachers need to ensure that we are responding to concerns of students. So salamat po, thank you very much. And I'm going to hand back now to Mary and Com Jojo for some final closing words and to invite you all for next week's session. Thank you.
Okay, thank you so much, Matthew, and thank you everyone for actively participating in the discussion in the breakout room session. So before we end today's session, we would like to remind everyone to send their group template in my email address at maria.gov@lev.gov.ph. I also send that email address in the chat box. Kindly access the same. And don't forget the registration form for your attendance and the evaluation form, which will also be sent in your email after this session. Okay, so a reminder to everyone for our October 6th second session, we will be sending the link for the Zoom in your email address as well as the program details. Please check your inbox and spam messages. Again, compliance to at least 9 sessions is required for the issuance of the training certificate. We hope everyone enjoyed today's sessions and see you on October 6th. Com Jojo, would you like to say some closing words or message?
No more. Just thank you, everyone. I'm enriched.
Okay. Thank you, everyone, for participating. This is very fruitful morning to every one of us. I hope you enjoy and learn learn from the discussion of our resource speaker for today. So see you on the next session on October 6th. Salamat po.